Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
All right, what is your name?
Kevin Caballero.
Kevin Caballero.
All right, I don't see a witness or a victim here. You have a battery domestic violence charge. I will appoint the public defender's office in all the cases this morning unless I state otherwise. I have made probable cause determinations on all cases unless I state otherwise as well. So I'm going to order you to have no contact with the victim, have separate residence. You may return one time with law enforcement to pick up personal items. Otherwise, no return. No weapons or firearms. And he qualifies for pretrial release date. Any objection?
No objection, Your Honor.
All right, so we should do pretrial release.
Sí.
All right, let's get the
Yes.
state and public defenders' names on the record.
Brenda Eugene on behalf of the State Attorney's Office.
Tyler Brands, B-R-A-N-Z, on behalf of the Office of the Public Defender.
¿Está bien? Sí.
All right, what is your name?
Álvaro Hernández Zúñiga.
Álvaro Hernández Zúñiga.
All right, you have a battery domestic violence charge. State you have a victim or witness here.
Yes, I am here.
One moment, Your Honor. Good morning.
Good morning.
Can you state your name for the record, please?
Sorry?
Can you state your name for the record, please?
Yes, my name is Ana Josefina Aguilar Gutierrez.
And how do you know the defendant?
He's my husband.
You live together.
Yeah,
While this case is pending, do you want to continue living with him?
yes.
Are you afraid of him?
No,
Were drugs or alcohol involved in this incident?
no, never.
Something like this happened before?
No, never. That was the first time. We are married for 4 years. I am not afraid of him. And I lied to have a contact with him. He's not a bad man, Judge.
I have no further questions, Your Honor.
All right, and he does not qualify for pretrial?
He could qualify.
He does? All right. So unless there's an objection state, I'll release him to pretrial release. Order no hostile contact with the victim. So you can reside together if you choose to, but nothing hostile, and you don't touch her against her will, obviously. Is that it for Spanish? Okay, thank you, interpreter.
Thank you, Your Honor.
We have a-
The move-ups?
Which one are we doing? This one? All right, what is your name?
Jan Otero.
What is it?
Jan Otero Mejías.
Othora Mias?
Yes.
Otero Mejas, Your Honor. Starts with an O.
Tara Mias.
Out of county cases.
Okay. All right, this is a violation of probation. There's no bond set. We have an attorney here? Do we have his case? Is there an attorney here? Okay.
Your Honor, can we skip Lorge?
Do them
He's-
later?
Yeah, we'll do him later.
Okay.
I have Mr. Gampa. Gampa, come on.
All right, what is your name? What is your name?
Dannon Gampat.
All right, you have several out-of-county warrants. The first one is no bond. The next three are $3,000 bonds. Public defender will be at least temporarily appointed until you're transported. Seminole County. Or what? Okay.
Your Honor, he's here. Lorge.
Okay. All right, what is your name?
Jimmy LaGreat.
All right, so you have charges of indecent exposure and failure to ID.
Your Honor, may it be heard?
Yes.
Just for your consideration, in determining bond, he has been found incompetent to proceed in most of his trespass cases. I have an order from Judge Allen, at least for 22 MM 0002, filed on 2/28, and there's a status hearing set for August 26th.
He was adjudged incompetent already?
He was a judge, yes, incompetent to proceed in that case, which I believe he's incompetent to proceed in all his cases.
All right, State, what would you like me to do with this?
I'm sorry, Your Honor. Are we talking about, he has an out-of-county, correct?
Are we talking about what?
Sorry, one moment, Your Honor. Oh, it's a reset. Oh, okay. Your Honor, I would ask that you take no action on his out of bonding, just give him bonds on the current cases.
Okay. I'll allow him to be released through mental health pretrial release, or I'll stay the bonds at 500 and 100. Take no action.
So it was either or, Your Honor?
Yes,
Thank you.
preferably mental health if he qualifies. Okay. What is your name?
Your Honor, I'm Michael Lafay. I represent Mr. Saeed Fadlullah.
Okay. All right, this is a battery, domestic violence. I don't see a victim or a witness here. And
I apologize, can you say the name again, please? Just the last name? And if it's felony or misdemeanor?
Saeed Fadlullah is spelled F as in Frank, A-D-L-U-L-A-H. Lima, Oullah.
Thank you.
All right, so it's battery, domestic violence. He qualifies for pretrial release. All or no contact with the victim, separate residence, no weapons. And state you want pretrial release? There's some kind of history with domestic, I'm not sure what it is, but
That case was dropped, Your Honor.
He qualifies, Your Honor. I have no objection.
all right, so pretrial release with those conditions.
Thank you, Your Honor. Mr. Fadlullah has his car keys and wallet over at the victim's house. I'm going to try and arrange a neutral third party to go pick that up, but in the event that fails, could I ask the court to authorize a one-time return with law enforcement?
Yes, he may return one time with law enforcement only to pick up his personal items, but there's still no contact when he's there.
Of course.
Okay.
Thank you, Your Honor. May I be excused?
Yes.
Good to see you, Your Honor.
Good seeing you.
Have a great weekend.
Hold on.
Hello.
Good morning, Your Honor. This is a sort of a request to cut the line type of thing. And I understand if I need to wait a little bit, but
Okay.
David Big.
Hey, hold on, hold on.
You have his client? This is his client. Oh, I thought you said it wasn't. Okay.
Okay, so you're gonna have to start over.
All right.
She's confusing me up here.
That's okay, and I'm sorry, and like I said, if you need me to sit back and wait for a while, I'll wait for a while. This is Supreme Richardson, and he's on your afternoon docket,
Yes,
and if.
we're set.
May we proceed on this?
Sure.
Your Honor, I have before me the affidavit for the arrest warrant, and I see that it's already been signed. I've reviewed it, and I don't have any argument as it relates to probable cause. Based on the four corners, I think that that's a fair assessment. But what I'd like to do is see if this court, despite the fact that as charged, it's a PBL, would consider giving Mr. Richardson a bond. Just a little bit of a background on Mr. Richardson, if any. I don't know that he has a record, but if any, it's minimal.
He's out on bond now.
Yes, but this does not violate that bond. It's my understanding that he wasn't picked up on that charge, and maybe I'm wrong.
It says he bonded November 30th of 2021.
Well, then this would, and I
Yeah.
understand that, and I thought it was a January arrest. I understand that. That's a marijuana case. The issue on that case, just to give you a little bit of background on that case, that's an open and shut case one way or the other. If it comes back as marijuana, then it's a plea. It's a case with a confession. If it doesn't, then it's a null process. And I understand that there's still that issue, that he was out on bond and there's a violation, but I wanted you to be aware of what that case is. And honestly, if this court were to revoke that bond, obviously we would be right in front of the judge, likely for a very quick plea within a few days anyway. So that bond would not have a major hindrance on Mr. Richardson if this court were to revoke it, but I'm asking the court not to revoke that bond anyway, just to give us a chance to. In other words, I don't want him to necessarily feel that the obligation to plead to something prior to the evidence coming in, but I know based on my conversation that just to get that issue resolved, that he probably would do that very quickly. Back to this case, again, that was a marijuana case. And on this case, that's the extent, I think, of his history. He's a 20-year-old man, given the allegations. Any conditions of release, I think, that would be reasonable would be obviously no contact, maybe weekly contact with pretrial release. And if necessary to get a bond today, my client is not opposed to an ankle monitor to be able to track where he goes and when he goes. Obviously, he'd like to have the ability to work, and so for those reasons, he's been a citizen here for some time now, and we'd like him to get a monetary bond.
Okay, I'm going to stay the bonds as set by the judges issued the warrant. There'll be no bond on count 1, $2,500 bond on count 2, no contact with victims, no return to the scene, not to possess any weapons. And state, as far as the cannabis, you want me to do anything with that or not?
Your Honor, in all honesty, I don't know what case we're referring to. It's from the afternoon, and I don't have that with me. I've not reviewed it, so I don't know.
Okay, he has a possession of cannabis with intent to sell or deliver, possession of more than 20 grams of cannabis, and I don't think there's any other history that I see.
Your Honor, only so we can be consistent, for every other case that has come through where someone is out on bond and they have committed a subsequent crime, or been accused of committing a subsequent crime, you have revoked the bond and held them at no bond.
Well, not every single time. This is a marijuana case. I know your office doesn't prosecute those very strongly, although this is a felony. So, yeah, I didn't realize it was a felony. So,
Yes, sir.
yeah, I'm going to revoke the bond.
Understood. Thank you, Your Honor.
Go to no bond.
All right, thank you. Thank you for letting me squeeze in.
Okay.
All right, let me talk to you for a second.
There's never an always, and there's never a never. There's always slight differences. Okay. All right, what is your name?
Nor Olive Kenny.
All right. Public defender will be appointed. State you have a witness or a victim here.
Yes, Your Honor. I apologize. What is the defendant's name?
Nor Olive Kenny.
Last name's A-L-A-F-G-H-A-N-I.
Good morning, ma'am. Can you tell me your name for the record?
Nadine El Hassouni.
And how do you know the defendant?
She's my mother.
Are you the victim in this crime?
You can call it that, yeah.
Okay, do you live together?
Not anymore.
Since when?
I'd say about 2 months, 3 months now.
Okay. So at the time of this incident, you were not living together?
We were living together.
Has something like this happened before?
No, ma'am.
Were drugs or alcohol involved in this incident?
No, ma'am.
Would you like to have contact with her while this case is pending?
Yes, I'm not afraid of her whatsoever.
Okay. I have no further questions, Your Honor.
Okay, so you're not going to be residing together?
As living together again?
Yes, from this point forward, if she's released today.
No, we will not be living together.
All right, she qualifies for pretrial release. State, any objection?
No objection.
All right, so we'll release you on pretrial release. I will order you to have a separate residence from the victim and order you to have no hostile contact with her. So she can come to your place if you want, but she's not to reside there. And no hostile contact with you.
Understood.
Anything else you want to say?
No, sir.
All right.
Your Honor, she is going to, I believe, move up into Duval County if she's able to do that while on pretrial release.
Yeah.
I believe she is.
I have no objection to it.
Thank you. Thank you.
All right, what is your name?
Good morning, Judge. My name is David Lee Coon, sir.
All right.
Ma'am, my eyes aren't that great.
It doesn't matter. I've been called worse and I've been called better. Ma'am's usually an upgrade.
I'm sorry, I thought she was
Yeah, she kind
That's
of looks
what
like
I'm
a
saying. I
judge.
can't even hardly,
She looks like a judge, doesn't she?
amen.
She does. All right. She's
Probably a
probably,
great helper.
yeah, she's probably a lot tougher than me, though, so. All right. So let's see here. We don't have a victim state, aggravated assault with a firearm, possession by a convicted felon. So there's nobody here. I'll order you not to return. Separate residence, no contact with a victim, no weapons or firearms. And the aggravated assault, I will set a $5,000 bond and a $100 bond on the convicted felon status. All right, your name?
Morning, Your Honor.
Hello, what's your name?
My name is Leo Francois.
All right, I don't see a victim here. You have battery by strangulation, aggravated battery on a pregnant person, battery domestic.
Your Honor.
Oh, hold on, sir, your attorney's there. If you need to say something, why don't you talk to him first?
Well, it was the attorney. It was the defense. But can I be heard on count two?
Oh, okay.
As
Oh,
to,
so it was you that spoke up?
yes, I'm
Oh,
sorry.
I thought it was him. Okay.
As to count two and probable cause, reading through the four corners of the affidavit, the victim was 9 weeks pregnant. She said that Mr. Francois was aware of that, but Mr. Francois was not interviewed. He remained silent. So we didn't have a confirmation that he had knowledge that the victim was pregnant. So I wouldn't have you find probable cause on count two and just drop it down to a battery.
She said he had knowledge, correct?
Yes.
Yeah, that's enough for me. All right, so you're to have no contact with the victim, no weapons or firearms, no return to the residence. All right, on the battery by strangulation, there'll be a $7,500 bond. Aggravated battery, there'll be an additional $1,000 bond, and the battery will be a $100. You may return one time with law enforcement to pick up personal items. All right, what is your name?
Good morning, my name is Tatiana Johnson.
Johnson, okay, this is battery on law enforcement, resisting without violence, and domestic battery. You have a victim state or a witness?
Yes.
Your Honor. Good morning, sir. Can you state your name for the record, please?
My name is Len Songlad.
And how do you know the defendant?
That's my child's mother, my girlfriend.
Do you live together?
Yes, ma'am.
While this case is pending, do you want to continue living with her?
Yes, I have no obligations to that.
I'm sorry?
Yes.
Okay. Are you afraid of her?
No.
Were drugs or alcohol involved in this incident?
No, ma'am.
Has something like this happened before?
No, ma'am.
I have no further questions, Your Honor.
Okay, so on the battery domestic violence, I will order you to have no hostile contact with the victim. You want her residing with you?
Yes, it doesn't matter. She
Yes?
can reside with me. I didn't have any domestic violence issue with her. I'm not sure why they put a charge on her. I was just trying to get in the house to go to sleep, and then I'm not sure what happened from there.
Okay, but you want her to reside with you?
Yes, sir.
Okay, so you may reside with him, but no hostile contact. And are there any weapons in the house?
No, sir.
Okay. And then you have, so that'll be pretrial release. Then you have the battery on law enforcement and resisting without violence. There'll be a $1,000 bond on the battery. And a $100 bond on the resisting. Okay, anything else, sir?
In regards to the battery, I know she did have a medical issue where she had an enlarged pituitary gland, which caused her to have multiple seizures after the childbirth. And from there, I believe that's the reason why she was so incensed, because I never seen her like that before. I'm not sure if there's any way you could look into that, but there is a medical history there, and it's still like ongoing to see just the severity of the pituitary gland growth.
All right, you can contact the state attorney's office. I'm sure they'll be in touch with you and go over all that with them, and they can do what they need to do with the case.
Yes, sir.
Okay, thank you.
Thank you.
Okay, what is your name?
Deshae Gerard, register.
Okay, public defender is appointed for you, and let's see, you have a warrant here, armed kidnapping, aggravated assault with a firearm, aggravated battery, and criminal mischief. I'm assuming the armed kidnapping's a PBL,
Yes, Your Honor.
so that'll stay at no bond. And you're not to return to the scene, no contact with the victim, no weapons. And kidnapping is what, an F1?
Yes, Your Honor. It too is a PBL.
It's a PBL? Okay, so there's no bond on that. The aggravated assault,
Your Honor, I would have you set bond in counts 1 and 2 unless you find proof evident presumption great.
we set those Arthur hearings off for the circuit judge. We don't conduct them here, as far as I'm aware, right?
I know I wasn't planning on doing an Arthur hearing. I was just asking the court to set a bond unless they find proof evident presumption great to hold them no
That is the
bond.
Arthur hearing.
I believe it's 2 separate functions, but if the court disagrees, they can still hold them no bond.
All I have is a warrant here from the circuit judge, and I'm going to stay the bonds, no bond and no bond, the aggravated assault and battery and criminal mischief. We'll each have a, the aggravated assault will have a $1,000 bond, the battery and criminal mischief will have $100 each. Again, no contact. And that means even if he's in jail, no contact. Hey, what is your name?
Good morning, Camden Richardson.
Okay, you have the public defender appointed. You have a victim or anybody here state? No? All right, looks like you have 8 charges. Aggravated assault with a firearm, aggravated stalking, violation of a condition of a pretrial release. There's 1, 2, 3, 4 counts of that. Extortion charge. And installing a tracking device on a vehicle. All right, any input from the state on these?
No, Your Honor.
Okay. On the, based on the facts of this case, the aggravated assault with a firearm, I'm going to set bond at $200,000. Again, no contact, no return, no weapons. And the other cases, I will set a $5,000 bond on each one of those, same conditions. I'm also going to order you not to possess or use electronic devices, including computers and cell phones. All right, your name?
Gary Brumfield.
It's a battery, domestic violence. I don't see a victim here. So we're going to order no contact with the victim, separate residence, no weapons or firearms. It says there's 5 failures to appear. I'm going to set your bond at $5,000. PD's appointed.
Your Honor, DCF was contacted regarding this incident. I would ask that he comply with any DCF plans.
All right, comply with any DCF plan that there may be.
Good morning, Your Honor. My name is Jason Dyer.
Okay, Mr. Dyer, battery, domestic violence. And there's no victim here. I'm going to order you to have no contact with the victim, separate residence, no weapons, order you not to consume any alcohol. Set your bond at $2,500. PD's appointed. Your name?
Chloe, Eugene.
Eugene, battery, domestic violence. I don't see a victim here. And you qualify for pretrial release. Any objection, state?
No objection.
All right, so we'll order you through pretrial release. You're to have no contact with a victim, separate residence, no weapons. Let's see. If you have any personal items at the apartment, you may return one time with law enforcement to pick up your personal items.
Good morning.
Hello, what's your name?
Rodolfo Sarmiento.
All right. Okay, there's not a victim here. You have a battery charge in violation of the condition of pretrial release. So I'm going to order no contact with the victim, separate residence, no weapons. You may return one time with law enforcement to pick up personal items. What's that? Oh. All right, what's your name?
Jose Malaver.
Yes.
Is your victim state?
Yes, Your Honor.
All right.
Good morning, sir. I apologize. Could you repeat your name?
Jose Malaver. Hello.
And how do you know the defendant?
He's my ex-boyfriend.
Do you live together?
Not anymore.
Since when?
Maybe 2 months ago.
Okay.
Yeah.
Were drugs or alcohol involved in this incident?
No, ma'am.
Has something like this happened before?
Sadly, yes.
While this case is pending, do you want to have contact with him?
I would.
Yes? Are you afraid of him?
I am not afraid of him, but there's just something that I would like to have under consideration, and it's regards to my mom. I just want him not to call my mom and to get in contact with my mom, and to make anybody else call my mom. Um, I know he's not a bad person, but he also uses my mom to in the middle of the heat of a moment, maybe trying to make her get worried about things, just to make me feel or hurt me. Sadly, it is like that. I don't know how else to say it. I don't want him to get in jail. I don't want him to be for too long here. I just don't want him to have any contact with my mom, and also to pay me back for all the things that I've lost that he has. I'm sorry.
It's all right. It's okay.
Please excuse me.
No, it really is okay. I don't have any further questions, Your Honor.
All right, appears he's out on bond on aggravated battery and false imprisonment with a weapon.
Yes, Your Honor.
All right, so that bond's going to be revoked. That'll go to no bond. You'll have to see that judge before you get a bond. And on this battery charge, I'm going to order no contact with the victim. You have a separate residence. You're not to possess any weapons or firearms. Zero contact, that means you don't contact anybody else, including his mother or anybody else, to contact him. If you do, you violate and you're coming back in jail with no bond. And that even means while you're in jail, you no contact, no phone calls, nothing. And I will set the new battery bond at $1,000 and the violation of the condition of release at $1,000. What's that? May return, well, does he have anything at your residence? Does he have anything at your?
No, sir, no.
Okay. You're in the shelter or something, or?
Yes, sir.
All right, your name?
Good morning, Your Honor. My name is Stephen Church.
Your Honor, do we know what happened to Saeed Badlula?
He had a private opinion.
Yes.
Oh, did he? Oh, I'm sorry. Apologies.
For some reason, your voice is popping over here. and I'm
I
thinking
should be a ventriloquist. And throw it across the room.
All right. All right, so this is a battery domestic violence, public defenders appointed. I don't see a victim or a witness here. We're going to order no contact with the victim, separate residence. You may return one time with law enforcement to pick up any personal items. No weapons. Set bond at $2,000. All right.
Thank you, sir.
Glenn is next. What's your name?
Jalen Glenn.
All right, you have an out-of-county warrant, Seminole County. There's currently no bond. We'll appoint the public defender as long as you're here. And once you're transported, Seminole County will deal with you and your attorney. All right, your name?
December Hayes.
All right, you have a Palm Beach County warrant. Your bond is set at $1,500. We'll temporarily appoint the public defender's office for you as long as you're here. What is your name?
Gene McKean.
Okay. Out-of-county warrant, Polk County, bond of $1,500. PD's public, or temporarily appointed for you while you're here.
I'm sorry, Your Honor, this is Gene McKean. He has a Volusia County warrant.
This is which one?
Gene,
What happened with Paul John?
Okay, yeah.
what's the booking number?
Yeah, yours is Volusia County warrant with no bond. Okay. All right, so this one is out-of-county warrant, Volusia County, no bond. Public defender is temporarily appointed. What's your name?
James Rogers.
Rogers. These are Pasco County warrants. We have 1, 2, 3, 4 at $10,000 and 3 at $2,500. And we'll temporarily appoint the public defender's office while you're here.
Your Honor, Soriano was a bond.
Sophia Simons? Oh.
Someone else.
What is your name?
Sophia Simmons.
All right, you have a warrant out of Osceola County, bond of $2,500. We'll temporarily appoint the public defender's office. You got two of them. They're both $2,500, so we'll temporarily appoint. Well, we'll go ahead and permanently appoint the public defender at this time, since it's Osceola County.
Thank you.
Moore?
We have Mathis, Your Honor. Moore's behavior.
Moore's behavior. All right, we'll temporarily appoint the public defender for the, well, no, we'll permanently appoint the public defender. It's an Orange County warrant, there's no bond.
This is for Moore.
Moore,
We'll waive the appearance as well, Your Honor.
okay? And looks like the PD was already appointed on his other case. State, I don't know if he was out on bond at that time. Looks like he was ROR.
One moment, Your Honor.
Oh, this is a VOP?
Yes, Your Honor.
Oh, okay. All right, so it's a violation of probation, so there's no bond on that. And I'll take no action on the other charges. It's a new one? All right, your name?
Good morning, Your Honor. Jordan Mathis.
All right, you have a violation of probation. Public defender will be appointed. The judge issued no bond.
Your Honor, we have Mosby as refusal.
All right, we'll appoint the public defender on Mosby. It's a no bond.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Good morning, Your Honor. This is Rafael Barrera, State Certified Court Interpreter. I have been previously sworn.
Okay, this is Judge Shoemaker. All right, what is your name?
Diaz, Alejandro Diaz Lopez.
I'm sorry, Your Honor, the interpreter has not confirmed connection to the headsets. Just a moment, please, Judge.
Sí.
Your Honor, the interpreter can confirm that the defendant is able to hear through the headsets.
Okay, then what is your name?
Alejandro Diaz Lopez.
Alejandro Diaz Lopez.
Okay, we will appoint the public defender's office. It says driving without a valid license and DUI, driving under the influence.
Perdón.
Excuse me?
You're charged with, driving without a valid license and driving under the influence of alcohol. Those are your charges.
Sí.
Yes.
And let's see. The bonds are 100 and 500. Public defender is appointed.
Your Honor, can the interpreter respectfully request a case number for this last defendant, please?
2022 CT 271 AA and
Thank you very much, madam. I'm sorry, go ahead, Madam Clerk.
2022 CT 272 AA.
Thank you, Madam Clerk.
All right, what is your name?
Reyes Eduardo Octavo Coto.
Reyes Eduardo Octavo Coto.
Okay, and we'll appoint the public defender on your cases. Your first one is 21 CT 35160. That's a violation of probation. So there's no bond. And then the how many are there? 3 or 2? How many cases are there?
Yes, two cases.
Total of 3? All right, and then you have DUI charge, bond of 500, driving without a valid license, a bond of 100. And is that, that's it? Okay. Public defender is appointed.
Sí.
Okay, he's bonded.
Under the interpreter, the defendant can hear through the headsets, Judge.
Okay, what is your name?
Javier Aguayo Aponte. Javier Aguayo Aponte.
Javier Abuello Aponte.
Okay, we'll appoint the public defender's office, and let's see. You have a capias here for failing to appear. You have 12 counts on this, no bond. Public defender's appointed. That's 2019 CF 8843AO. What is your name?
Y buenos días. Anderson Moreno.
Good morning, I'm Anderson Moreno.
All right, we will appoint the public defender's office. And there's 2 cases here. You have the what's this? $79. All right, you have the 2019 CF 1979 AO. Those are burglary of a dwelling and criminal mischief. That was a probable cause warrant, okay. So I need to set bond on those, State, I would assume.
Yes, Your Honor.
All right.
Sí, su señoría.
Yes, Your Honor.
We're appointing the public defender on your cases. And the burglary of a dwelling will be $5,000, a criminal mischief 100. No return to the scene, no contact with victims or witnesses. Then you have the 2019 CF 1982AO, another burglary of a dwelling and criminal mischief. And that'll be a $5,000 bond and a $100 bond. Again, no contact with a victim or witnesses, no return to the scene.
Ok, muchas gracias.
Okay, thank you very much.
That's it. All right, that's it for the interpreters. Thank you.
Thank you, Your Honor. Have a good weekend.
Mhm. All right, what is your name? Rio. You there? Interpreter?
Yes, sir.
Okay, and what is your name?
Ruth, or UTH.
All right, and you're going to interpret English and Creole?
Yes.
All right, and you swear to do that truthfully to the best of your ability?
I do.
Okay. And what is your name, sir?
Enoch.
C'est qui Jean Relais?
Enoch Guillaume.
All right, we'll appoint the public defender for you.
Nous pral chercher un avocat pour.
There's one case. Okay, bond is set at $10,000 on a failure to appear.
There was an offer to resolve, Your Honor. I did have a chance to speak with Mr. Guillaume before court. So withhold and time served,
I don't even know what the charge is.
and driving while license suspended.
Is it going to habitualize him?
It's a failure to appear on that. I'm sorry?
Will it habitualize him?
I don't
No,
believe
It's
so,
his
Your
only
Honor.
one.
I think it's his only one, yes.
Nope.
No, it's a withhold, Your Honor, but it is his only offense.
I checked with the client before court as well on that. Oh, yeah.
So he wants to enter the plea?
I believe so, Your Honor. On the terms of the withhold and time served.
All right, can the interpreter ask him if he wants to enter a plea of guilty or no contest to the charge?
Monsieur, li di ki Jean vle plaider, est-ce qu'on vle di que ou pas coupable ou bien que ou pas bataille pour ça ou condamné ou pour li?
My culpable, so my. You meant,
I'm guilty.
yeah.
I'm guilty.
Okay, have you gone over a plea form with him?
Yes, Your Honor. I give him,
Right.
went over the plea form, gave him one to review and read before court as well.
All right, we need to ask him if he read the plea form and understands it.
Monsieur, form yo te pour plaider, est-ce que te li, est-ce que te comprendre qui ça sous forme là?
Yeah.
Yes.
And this is a charge of driving while license suspended with knowledge of first offense?
Yes, Your Honor.
The state's offering a withhold, time served?
Yes, Your Honor.
All right, so to your charge of driving while license suspended with knowledge. What is your plea? Guilty, not guilty, or no contest?
Le fait yo condamné ou parce que ou t'a conduit ou connaît que licence ou te suspendé pour t'a conduit alors qui j'ont plaidé est-ce qu'on dit ou coupable ou pas coupable ou bien ou pas contesté contre lui
Moi coupable.
guilty
Right. And defense stipulate to a factual basis?
For the purposes of the plea, yes, Your Honor.
All right, then I'll withhold adjudication. You have credit for 2 days in jail. You have court costs to pay. That's due within 180 days of today. If not, report to the clerk's office for a payment schedule.
Alors, monsieur, ou gen un crédit parce qu'on fait 2 jours en prison et vous gen frais pour payer, ou gen 180 jours pour qu'à payer frais ça, commencer compter jeudi.
And then you'll be released as to this case today.
Et puis, yo pral relâcher aujourd'hui.
Oh, y a plagué moi aujourd'hui, hein?
So I will be released today.
As far as this case goes, I don't know if there's anything else.
No, he has nothing else.
Nothing else?
Nothing else.
Yes, he'll be released today.
Oui, y a relâché aujourd'hui.
Thank you.
All right, what's your name, sir? Thank you, interpreter.
You're welcome. Thank you for using our service.
Morning, Your Honor. My name is Wali Rashid.
All right, you have a disorderly conduct charge. We'll appoint the public defender's office. Is this playable or not, or?
Standard offer from the city or the offer from the state on behalf of the city is a withhold and time served. If I can have a moment to confer. Okay. As I said, Your Honor, thank you for allowing me a moment. Offer is withhold, time served. Mr. Rashid would like to resolve today with a no contest plea. It was a panhandling charge. I believe it was a banana that was the object, passing hands. So as for the record,
Yes.
you sign in the plea form now. I made sure that any probationary or citizenship issues were okay with Mr. Rashid.
All right, so sir, did you understand everything on the plea form you've signed?
Yes, sir, I did.
And you understand your charge of disorderly conduct?
Yes, sir.
And what is your plea?
Guilty, sir.
Guilty? Not
No contest, sir.
no contest? All right. We'll withhold adjudication. You have credit for 2 days in jail. Court costs due within 180 days. We'll report to the clerk's office for a payment schedule.
Okay, sir.
Be released as of this case today. What is your name?
Why'd you guys leave?
All right, you have a charge of trespassing. Public defender is appointed. Mhm.
Your Honor, there is an offer to resolve from the state an adjudication of guilt, credit time served, no return. I did speak with Mr. Leaks. I believe he wishes to resolve with a no contest plea today. He is familiar with the plea form and understands any probationary and citizenship issues.
All right, did you read and understand your plea form, sir?
Yes, sir.
You got to speak up.
Yes, sir.
All right? And you understand your charge?
Yes, sir.
Then I'll order a no return to the Wawa on South Orange Blossom Trail.
Okay.
So what is your plea to the charge?
No content.
Right, you understood everything on the plea form you've signed?
Yes.
All right, then I'll accept it and adjudicate you guilty, credit for 2 days or 1 day in the county jail.
2 days, Your Honor.
2 days? Okay, 2 days. And you have court costs to pay within 180 days, or report to the clerk's office, and then there's no return to that location.
Okay. Thank you.
Good morning, Your Honor.
Hello, what's your name?
I wish I was young.
What's your name?
Ralph Gildart.
Okay, you have aggravated assault with a firearm. Public defender is appointed. We're going to order no contact with the victim, separate residence. You're not to possess any weapons or firearms. And I'll set bond at $3,500. PD's appointed.
Okay. I can't see that. Okay. Thank you.
Your Honor, Butcher is mental health.
Okay, so we'll appoint the public defender's office.
We'll waive the appearance, Your Honor.
Okay, stay the bond at $500. No return to Home Depot. No contact with victims or witnesses. All right, what is your name?
Jamal Cleus.
Okay, we'll appoint the public defender's office for you.
Your Honor?
And you have possession of cannabis less than 20 grams? Yes.
Your Honor, with regard to the possession of cannabis charge 22 MM1601, state announces a no information.
Okay, so I won't mess with his pretrial release on that, since he'll be released.
Ms. Davis, do you need to fill this form out?
I'm sorry?
Do you need to still sign this form?
If he took no action?
Mm-hmm.
He would just put the,
Doesn't apply.
He's done. He should be out.
Dismiss the case.
the first box. Okay.
Okay. Did he already leave?
Oh, you still need it?
Still have the second case, right?
I mean,
Yeah. She infoed the old one. Only one. There's only one? Okay, yeah, I looked at the wrong case number. Okay. That's a felony. So you've null pros the new charge, correct?
Yes, Your Honor.
Or no infoed it? All right.
Yes.
So then we'll take no action then on that. Yes, I'm losing my mind sometimes.
Okay.
Sometimes I don't know where I'm at. Okay. We have Benjamin Morris, public defender will be appointed. This is trespass on property after warning.
Your Honor, just for the record, I did speak with a lot of the pleables as a friend of the court, so we may not need to be appointed, save them $100, I think. I did speak with Mr. Morris as a friend of the court. In this case, there was an offer to resolve from the state, an adjudication of guilt, time served, no return. I did go over that offer with Mr. Morris as well as a plea form. I believe he wishes to resolve no contest today.
Is that what you want to do? Got to speak up.
Yes, sir.
All right. Did you read and understand everything on your plea form?
Yes, sir.
And you understand the charge of trespassing?
Yes, sir.
All right. What is your plea to the charge?
No contest?
All right. I have a factual basis in the arrest report. I'll accept your plea. We'll order you not to return to
Epcot.
Epcot. And you have credit for 2 days?
Yes, correct.
And you'll have court costs to pay within 180 days. We'll report to the clerk's office for a payment schedule. Adjudicated guilty. Thank you.
Sure.
All right, what is your name?
Yvonne Marie Murillo.
Okay, you have a new charge of the inhalation of a harmful chemical. Public defender is appointed.
There was an offer to resolve this case as well, this current case, Your Honor. The offer from the state was an adjudication of guilt and time served. I did talk with Ms. Murillo about the state's offer as well as went over the plea form with her. I believe she wishes to resolve no contest today.
I'm not going to accept that on her case with 3 felonies, 7 misdemeanors. It has this prior offense. She's out on bond on battery on a firefighter, petty theft, and the same charge.
Then, Your Honor.
I'm going to revoke bond on those charges. Those will go to no bond.
All 3 cases, Your Honor?
Yes. And then her new case, the bond will be $250. Public defender is appointed.
Your Honor?
Yes.
Watson is mental health.
All right, we'll appoint the public defender's office.
It was mental health?
Yes, sir.
We'll waive the appearance, Your Honor.
Okay, we'll order him not to return to the property. Not to consume alcohol. We'll stay his bonds at 500 and 500. Public defenders appointed. All right, your name?
Rena Kuhn.
All right, you have a failure to appear, bond set at $500. I'll appoint the public defender's office.
There was an offer to resolve this case as well, Your Honor, from the state, an adjudication of guilt, time served, no return. I did speak with Ms. Kuhn about the terms of the offer as well as went over a plea form, went over the citizenship and probationary issues as well as the enhanceability of petty theft charges. I believe she wishes to resolve no contest today.
I don't even know what she's charged with.
It's a petty theft. It's a failure to appear on a petty theft set at $500 bond.
It says no felonies or misdemeanors, but then it says,
Okay.
well, that's out of state. She's got forgery theft. She's got several theft-type cases, so I'm not going to accept that.
Have you stay the bond then, Your Honor?
I'll stay the bond at $500.
Your Honor, I ask for a no return.
No return to the location. All right, your name? What's your name?
Anthony Valma.
All right, you're here on a failure to appear. There's a $1,000 bond. Petty theft.
Your Honor, there was an offer to resolve, and I did have a chance to speak with Mr. Valman. May I have another moment to speak with him? Thank you, Your Honor. The offer from the state was a withhold, oh, excuse me, by the way, this was a failure to appear on a petty theft, set at a $1,000 bond. Offer from the state was a withhold, time served, no return, and an impulse control course taken within 60 days. I did, like I mentioned, spoke with Mr. Valman about the offer from the state, went over the plea form, probationary and citizenship issues, as well as the enhanceability of a petty theft charge. I believe he wishes to resolve no contest today.
Yeah, he has an extensive out-of-state history too, dealing with robberies and thefts and. So that's something I would not accept.
We would just have you stay the bond then, Your Honor.
$1,000, no return.
I'll take your phone. Sorry.
Okay, what's your name?
Deborah Cooks.
Okay, we'll appoint the public defender. You're charged with urinating or defecating in public.
In the bucket.
Yeah, I read it.
Okay.
There was an offer to resolve on behalf of the city. The state offered to withhold and time served. I spoke with Ms. Cooks about that offer, went over the plea form with her, and I believe she wishes to resolve today.
Okay,
And I spoke with her as a friend of the court, so.
all right. All right, so did you understand everything on the plea form you've signed?
Yes, sir.
And what is your plea to the charge? Guilty, not guilty, or no contest?
No contest.
All right, then I'll accept your plea, withhold adjudication, credit for 2 days? Court cost to pay within 180 days, a report to the clerk's office for the payment schedule. Your name?
Cotton Lima.
What is it?
Cotton Lima.
Lima?
What happened to loan?
Hello, was a bond.
I have a moment to confer, Your Honor.
No, this is,
What happened to Lima?
this is Lima.
This is Lima.
Don't be blaming me. Don't be blaming me. But you try to blame me. I didn't do anything.
Your Honor, this is Codlin Lima, traffic case.
Okay, this is a driving an unregistered vehicle.
Yes, Your Honor.
And there was an offer to resolve from the state, Your Honor, as a withhold time served. I spoke with Mr. Lima in the back, went over the plea form with them, and clarified again in court if you wish to resolve today. I believe he wishes to resolve no contest.
All right, is that what you want to do, sir?
Yes, Your Honor.
All right, did you understand everything on your plea form?
Yes, sir.
Do you have any questions?
No, sir.
And then what is your plea to the charge?
No contest.
All right, I'll accept the plea, withhold adjudication. You have credit for 2 days in the county jail. Court cost, pay within 180 days, or report to the clerk's office.
I spoke with Mr. Lima as a friend of the court, Your Honor.
All right.
I'll let you have today. Okay.
I'll go there.
Yes.
What is your name?
William Abreu.
All right, you have a failure to appear. There's no bond on that failure to appear. Capias, public defender will be appointed. All right, your name?
Michael Chisholm.
All right, you're in a grand theft third degree. Bond was set at $1,500. And you have burglary of a structure, bond set at $3,500, grand theft, $1,000, dealing in stolen property, $2,500, criminal mischief, $250. No return to the scene, no contact with victims or witnesses.
And Your Honor, as to the out on bond case, may I be heard?
That says it's still an open case, so he's not in custody on that, or been charged, or been arrested, or anything?
I believe the warrants and the dates of the events in the warrants that are before you today predate the arrest and bond date of the out on bond case.
Okay. So I'll take no action. Okay? All right, your name?
Roberto Cruz, Jr.
Cruz? All right, you have robbery with a deadly weapon, came in at no bond. You're going to be ordered not to possess any weapons or firearms, no contact with the victim. What's the state's position on that bond?
Your Honor, robbery with a deadly weapon is a first-degree felony punishable by life. I would ask defendant be held no bond.
Defense would argue setting a bond in this case unless the court finds proof evident presumption great.
Okay, I'm not going to make that finding today. I'll reserve that for another judge on another day. I will holding no bond pending that finding.
Talk to him.
Your name?
Matthew Gamma.
All right, we'll appoint the public defender for you. You have possession of hydrocodone, Xanax, methamphetamines, cannabis, and drug paraphernalia. Bonds of 1,000, 150, 150, 100, and 100. I'll stay those bonds.
Your Honor, we have Jasmine Griffin as a surety bond.
Bonded? All right, your name?
Nathan Griffin.
All right, you have failure to appear. There's currently no bond set. We'll appoint the public defender's office.
Your Honor, we have Hooks as refusal.
Okay, we can appoint the public defender's office.
We'll waive the appearance, Your Honor.
All right. The new charge, there'll be a $1,000 bond, and then she's out on bond. Or he, I'm not sure which it is, but he.
Yes, it's a male.
It was released on 3/9/22 and got this 3/10/22. All right, we'll revoke the bond in the 22 CF 1397AO, and that'll go to no bond. Your name?
Danny Abera.
Vera. All right, let's give them false information to law enforcement. Appoint the public defender's office. Stay your bond at $2,000. What's your name? All right, Mr. Jackson. Public defender will be appointed. There's Robbie with a firearm. Public defender is appointed. I mean, what's the state's position on this?
Your Honor, robbery with a firearm is a first-degree felony punishable by up to life. State at this time would ask defendant be held no bond. Your Honor, there is also a co-defendant, David Olds, who was also arrested. I would ask that there be no contact.
We're going to order no contact with the co-defendant or the victim. not to possess any weapons.
May defense be heard, Your Honor?
Yes, go ahead.
As to proof evident presumption grade, I would have this court find that before setting no bond. Reading through the four corners of the affidavit, I believe the co-defendant may or may not have been carrying a gun, not Mr. Jackson. Also,
Does it say who was carrying the gun? I couldn't see where the gun was used, but maybe to hit somebody in the head?
I believe there was a hard object, that's a
Right.
quote. The gun was found nearby, so the officer, I guess, presumed.
Right.
But although it's the state's burden to show proof evident presumption grade, I would argue that there's not enough there, and so he is entitled to a bond.
We got 5 felonies and 7 misdemeanors. I'm going to set bond at $50,000. Again, no contact with the victim, no weapons, no contact with the co-defendant. State can file a motion for pretrial detention if you choose to.
Yeah, we'll come see you.
Your name?
Excuse me? Jelani Jones.
All right, yeah, possession of cocaine, public defender will be appointed.
Can it be heard as to this charge as well, Your Honor? I'm sorry, may I?
Yes, go ahead.
I believe the bond on the arrest affidavit was $30,000.
Right.
I believe that's connected to the bond schedule charge. Within the arrest affidavit, it was 5.5 grams, but there was no cash, no scale, no evidence of transaction.
Right.
So I would have you set a lower, if you do find PC on this charge, I would have you set a lower monetary bond.
Anything from the state?
No objection, Your Honor.
What's that?
No objection.
Okay. I'll set a $5,000 bond.
Thank you, Judge.
Your Honor, just for clarification, did you lower the bond because you didn't find PC with the intent, or just lowering it based on the facts? I'm just trying to, I have no objection to it being lowered. I'm just trying to determine as to the reason why. Does that make sense?
Based on all the facts.
Okay, so with regard to PC, did you find PC for the possession with intent or just straight possession?
Straight possession.
Thank you.
All right, your name?
Eric Keenan.
All right, public defender is appointed. Let's see, what is this? Does it say violation of pretrial release?
No, this is.
No, it's a probable cause order.
Yeah.
All right, so it's a charge of petty theft with 2 prior convictions. We'll appoint the public defender's office.
And, Your Honor, the warrant does say PTR, but we asked if you strike PTR because he does not qualify.
Okay.
But because it's a warrant, Your Honor, you would be able to set bond on it.
Yes, I'll set a $1,000 bond. No return to the location, no contact with victims or witnesses.
Can you tell me what it is? Because I don't know.
State, can you look it up and tell them what it is? I don't have anything on it.
One moment, Your Honor. Looks like it's the Walgreens located at 4502 South Orange Blossom Trail.
All right, your name? Mr. Knight?
Yes, sir.
All right, there's a warrant here for your arrest with robbery with a firearm. No contact with a victim or witnesses, no weapons or firearms, no contact with co-defendant, and do not return. And this is punishable by life, correct, State?
Yes, Your Honor.
All right, defense, what do you want to say?
I would have you set a bond in this unless the court finds proof evident presumption great to hold him no bond.
All right, I'm going to holding no bond pending his Arthur hearing. All right, what's your name?
Roy Lee Lovett.
All right, petty theft with 2 prior convictions. Public defender will be appointed. Bond is stated at $2,500. You're not to return to the Publix on 400 Central Boulevard, East Central. No contact with victims or witnesses. What's your name?
Paul Madsen.
All right, you have a DUI charge. Public defender will be appointed. And this says a 4th DUI, State. I don't know how he came to that conclusion. Do you?
I do not, Your Honor. Would you allow me 24 hours to try to get the additional information, Your Honor?
We'll appoint the public defender's office.
If it's not within the arrest affidavit, you can just find PC for 1 DUI, but the state is entitled to 24 hours. If you choose to reset it, that is, Your Honor.
I can set bond as if it is a 4th, or we can reset it for PC.
A moment to confer, Your Honor.
It's basically staying the bond at 5,000. We don't have any Davids today.
You want me to print one out for you?
Sure. We may be able to get that information.
We'll just have you reset it till tomorrow, Judge.
I'm going to get his David pulled up here, I think.
I'm sorry? Oh, we're gonna look at it now, okay. That's fine.
This appears to be a fourth based on his driving history. Has his name and date of birth, so, right. Probable cause will set bond at $5,000, not to consume any alcohol, he's not to drive without a valid license. He's appointed. Your name?
Name's Jose Negron.
Gron. Public defender will be appointed. Through the lascivious act on a victim 12 years of age or younger. And there'll be no bond on that. You have no contact with the victim. Or any witnesses. I believe there's a sister that was a witness potentially, so no contact with the victim or the sister.
Supervised contact with any minors, Your Honor?
Right, not to, any minor you're around, you're gonna be ordered to have another adult there, so no unsupervised contact with minors.
And then no bond? Oh, go ahead.
I apologize, Your Honor. I believe this happened in the home, so I would also ask for a no return. Yeah, I just asked for
No return to the residence.
Thank you.
And because of the no bond status, the court found proof evident presumption grade pending an Arthur hearing. Is that correct? For the record?
In that case, yes.
I believe it's
There is
punishable
proof
by-
evident presumption great based on what I read, but I'm not doing an Arthur hearing at this point.
No, not Your Honor. We would reserve the right to the Arthur hearing.
All right, your name?
Brendan Newton.
All right, you have, let's see. It's a warrant for grand theft, third degree of a vehicle, bond of $3,500, no contact with the victim or witnesses. PD's appointed. All right, your name? Your name?
David Olds.
All right, and you're co-defendant on Melvin Jackson, so I'm going to order you have no contact with the defendant or the victim in this case, not to possess any weapons or firearms. Co-defendant's Melvin Jackson. No contact? All right, this is that same set of facts state.
Yes, Your Honor.
It's the co-defendant. So what's your position on bond again?
Again, Your Honor, this is a first-degree felony punishable by life. State would ask defendant be held no bond.
And Your Honor, as to my argument with the co-defendant, I would have you set a bond amount unless you find proof evident presumption grade, but we did talk about the facts as well in this case. In the interest of equity, I would have you set the same bond amount for the co-defendant.
So is there any evidence in here state that he possessed the firearm?
Only that of his co-defendant, Your Honor.
It was on the ground next to the co-defendant, right?
Your Honor, may we approach?
Okay. All right, so on the robbery with a firearm, I will set the bond at $50,000. I'll stay the other bonds at $3,500, $4,000, and $4,000. No contact with the co-defendant, the victim, or any other witnesses, not to possess any weapons or firearms. All right, your name? Olson? Okay, we have a warrant here. Burglary of a conveyance, bond of $3,500. Grand theft, dealing in stolen property, or $500. Another dealing in stolen property, receiving money from a pawnbroker, $500 each on those. Another receiving money from pawnbroker at $500. False information to the pawn dealer, 2 counts at $500, total of $7,000. No contact with the victim, no return to the scene. So that means do not return to the pawn shop as well. Public defender is appointed. All right, your name?
Edward Thomas Ox.
What is it?
Edward Thomas Ox.
Now, let's see if we need it. All right, we'll appoint the public defender. You have a warrant here for burglary of a structure, $3,500, petty theft, $500, and criminal mischief, $500. No contact with victims or witnesses, no return to the scene. PD's appointed.
Your Honor, can I ask you a question?
Talk to your attorney first.
Pretrial, Madam Pretrial, is there any holds on this client?
No.
If he's able to bond out on these?
Go that way, Mr. Ox. Come up here.
All right, your name?
Mark Andy Pierre.
All right, possession of a short-barreled gun or rifle, possession of a firearm by a convicted felon. Public defender will be appointed. Did we
A moment to confer, Your Honor.
get in here? There it is. Mhm.
Thank you, Your Honor.
Okay, on the, you're out on bond on 2022 CF 550AO. That bond will be revoked and go to no bond, both of those.
What was the bond amount on the current charges?
I'm getting to that now.
Oh,
I'm going to set $5,000 bond on each count. Not to possess any weapons. And no contact with co-defendants. What's your name?
Josh Powell.
Powell, you have a warrant here. Trafficking in methamphetamine over 28 grams. Public defender will be appointed. And set bond at $20,000. Your name?
Christian J. Rosa.
You have grand theft, the motor vehicle. Public defender will be appointed. And set your bond at $2,500. All right, your name?
Travis Sam.
Okay. You have 4 cases, it looks like. Possession of cocaine. 22 CF, that's the 2703. March the 10th, you were out on bond. The 2021 CF 16064. That will go to no bond. And the same with the 22 CF 790. That will go to no bond. And we'll stay the $1,000 bond on the new charge. And then you have delivery of cocaine within 1,000 feet of a business, sale and delivery of cocaine, possession of cocaine. I'm going to set those bonds at $2,000 on each charge. And on the 22 CF 1192AO, delivery of cocaine. Another within 1,000 feet of the business, possession. And those will be 2,000 per count. And you have another sale and delivery of cocaine, possession of cocaine. And that'll be 2,500 and 1,000. Okay. Your name?
Vidal Smith.
Try to speak up.
Vidal Smith. Vidal Smith.
All right, 2 cases, public defenders appointees are failures to appear. Bonds of 2,000 and 300. And there's a robbery. You're ordered no contact with the victim, no return to the scene, not to possess any weapons or firearms, no contact with the co-defendants. And that bond is $5,000. What is your name?
David Swakowski.
Okay, you have violation of condition of pretrial release. And the judge set that at no bond. And then you have possession of a firearm by a convicted felon, resisting without violence. The firearm charge will have a $10,000 bond. You're not to possess any weapons or firearms. Resisting will be a $100 bond. Oh, wait a minute. No. Let me see here. Does the judge revoke these bonds?
Yes, Your Honor, are you talking about for case 7695?
Yeah, 7695, the judge revoked those bonds, they go to zero. Till you see that judge. The 85, 9, no. 21 CF 7695. It's the one we just did. Those are no bond by the judge. Okay. And then the burglary of a dwelling or with assault and battery, that's a PBL, is it not?
Yes, Your Honor.
So that will go to no bond at this time. No contact with the victim, no return to the scene, no weapons. And we have the failure to appear, there's no bond. That's on the 14361.
Your Honor,
Is that all of them?
Yes. That's all.
Mm-hmm.
as to the PBL, are you finding proof evident presumption grade to hold him no bond?
Not at this time, no.
And on count two, the violation of condition of pretrial release, case 21 CF 12108, I believe you can't set a bond in that case. I don't believe you can hold him on no bond on that charge.
State,
Yes, Your Honor, he is entitled to a bond.
that's on which one?
21 CF 12108, the violation of conditional pretrial release.
And he's out on bond on trafficking,
Possession
possession.
and a grand theft.
All right, so the bond on the trafficking in 28 grams or more will be $100,000. And the other two will be $1,000 each.
I'm sorry, on what, Your Honor?
What's that?
On which case are you referring to?
What?
On which case are you referring to with the bonds?
Yes.
That's a new charge, Your Honor.
Okay.
So he may have violated the conditions of release in the trafficking case that you're referring to, or the possession case, excuse me. So but he would be entitled to a bond amount on the violation charge.
Oh, I see what you're doing. Because there's supposed to be 3 counts.
I thought I Was he out on bond then? On 1822? Let's see. Take bond. 22. Yes. Committed the burglary with the assault, so we're gonna revoke the bonds in 2021 CF 14390, 22 CF 247. Okay. Leave them private if they have private, if not, appoint the PD.
What was the final bond amount on the violation? I'm sorry. The new 2021 CF 12108.
What was it? 100,000, 1,000.
I have a moment to confer.
What is your name?
Bruce Taylor.
Taylor, public defender will be appointed. You have a failure to appear. There's no bond.
Speak. I'm gonna go already?
That's it.
Give us a call. We're gonna set a court date.
Just saying that.
What's your name?
Jordan DeAndre Trent.
Trent. All right, we'll appoint the public defender. You have a failure to appear with a $5,000 bond and a $100 bond. Your name?
Shane Ultimo.
This is a robbery, battery, and petty theft. Do I have his history anywhere? No.
Timo?
Do you have it somewhere? I don't see it.
No, he don't
No.
have it. No.
I don't see it. I don't say I don't have it. I don't see it. All right, so there's out-of-state burglaries, thefts, frauds, sex charges. He's out on bond on another case? No. It says in here. 22 CF 1838 AO.
It says that in the notes, but I don't see it on the face sheets. I don't know which is accurate.
That was at the time when he first came in, he was out on bond, but these are just add-on charges.
Okay. So based on his history, I will set bond on the robbery at $20,000, followed by 100 and 100 on the misdemeanors. No contact with victims, no return to the scene. What is your name?
Right.
All right, Mr. Wright. You have new charges of possession by a firearm, possession of a firearm by a convicted felon, possession of ammunition by a convicted felon, grand theft third degree firearm, possession of cocaine and cannabis. A public defender will be appointed. Thirteen felonies, 3 misdemeanors, a failure to appear. And case the one he's out on release, a 2022 CF 261AO. Is your office prosecuting that, or have you made a decision?
Your Honor, he was arrested January 7th, but as of today, formal charges have not been filed.
He was arrested on it?
January 7th.
All right. I'm going to revoke the ROR, set that at no bond at this time. And on the possession of a firearm by a convicted felon, that bond will be $5,000, as well as the possession of ammunition, $5,000. The grand theft will be $5,000, and the cocaine and cannabis will be $100 each. Yes. All right, what's your name?
Willie Young the third.
Okay. Yeah, possession of cannabis over 20 grams, resisting without violence. Bonds will be 1,100. You're out on bond. 21 CF 1199280. It'll be revoked and go to no bond. Public defenders appointed.
Your Honor, I think there's another charge of resisting, but I think it stems from the same facts. I don't know whether there's 2 charges, a misdemeanor and one included in the felony charge.
Yes, there's another resisting charge.
I would just have your ROR on that second one, because I think, as I said, I think it stems from the same facts. He's also being held here, no bond on the out of bond status.
Okay, that can be our order. Anything else? That's it.
Nothing from the defense.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond Court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.